Why did you wake me up? I was studying. Come, let's go put away case law frustrations. Let's empower South Africans with legal knowledge. This video is based on legal causation under the scope of Novus Actus interveniens. You might need to grab your notepad and pen. This is a very interesting, not difficult but challenging portion in criminal law. In order for you to confidently and accurately answer questions in this topic, you need to know the decided case laws. For the purpose of making sure that you fully understand, we shall make an exception and summarize more than one case law. The purpose of causation is to determine who was at fault. It narrows the scope of liability and establishes the appropriately closest cause of the unlawful consequence, death. There are two tests which help us to determine who is at fault. In order for us to conclude whether or not the accused is reasonably liable for the unlawful act, we must prove both these tests. Namely the factual causation, but for test, and the legal causation. In most cases, proving factual causation is easy since we use but for test. There are various tests that can be considered to determine the legal cause. However, in SV Mokgethi, it was ruled that the court must take into account one or more of the following factors: proximate cause, feasibility, adequate cause and absence of Novus Actus interveniens. A Novus Actus interveniens is a new intervening act or event, which after the accused's act has been concluded, it either causes or contributes to the consequence. It breaks the causal link. Now we will be discussing factors which helps in determining if something is a Novus Actus or not. 1. The act or event must be abnormal or unlikely. 2. In SVM Bambo, it was submitted that an act or event stands a greater chance of becoming a Novus Actus interveniens, when the injury inflicted by accused is not fatal or deadly. 3. Accused need not be the only consequence. Meaning, if two people acting independently inflict successive wounds on the victim who dies from combined effect, the second wound will not in this case be a nova causa. 4. A voluntary conduct is more likely to be a nova causa than involuntary conduct. 5. The act or event must be unforeseen, even if it was an abnormal event. If it is foreseen that it could end in tears, the offender will be liable. For example, X attacks Y, Y is being rushed to hospital in an ambulance and it is foreseen by X that the ambulance may be involved in a collision and Y may die as a result, but X continues to put Y in that ambulance. X in this case could be charged with murder. 6. Medical intervention will only constitute a Novus Actus interveniens, if the intervention was negligent or improper in some way. In SV Williams, it was decided that, where a person is so seriously injured that they would die in any event without medical intervention, if intervention is not given, such omission or resistance to intervene is not the cause of death. In this case, the accused shot Y in the neck and Y lost lots of blood. Y received medical treatment but it was found that she was brain dead. Only Y's heart and lungs were functioning because of the respirator. So the family disconnected the machines. It was held that turning off machine is not a Novus Actus, as there were no negligent or improper medical treatment. Still on medical intervention, in SV Counter 2003, the Supreme Court of Appeal had to decide whether the accused or doctors should be convicted. The accused shot Y. Bullet lodged in her buttock. Unbeknown to her and doctors, it penetrated her anal canal and caused wound to go septic, which resulted in her catching pneumonia, consequently Y died. The court held that the sequence of events from the time she was admitted to hospital to time she died was not interrupted by any causal factor which may have affected the natural order of events. Therefore, there was no intervention or omission by people responsible for her care. 8. Subsequent conduct. In RV Mabol, X stabbed Y in abdomen. It was not considered to be particularly dangerous, but Y's condition deteriorated and doctor did exploratory operation, which confirmed no penetrating wound, but the operation caused obstruction of an artery unrelated to knife wound and unfortunately, Y died. The court held that medical attention was given with goodwill and efficiency, and the accused cannot complain due to a mistake in the diagnosis or treatment. Court held that there was no medical negligence and therefore there is no nova causa. However, acknowledged that but for the medical treatment the deceased would have survived. 9. Suicide. In S.V. Grosjean, the accused gave his wife a gun to shoot herself, and when she did he claimed it was a nova causa. However, from the surrounding circumstances it was clear that she would have killed herself and it was foreseen by him. The court ruled that the wife is unintelligent and short-tempered and the husband can foresee that she would actually do so. The court decided that it is not a Novus Actus intervenens. 10. Subsequent conduct on the accused's part. If accused performs a subsequent intervening or negligent act that is completely separate from the original act which causes the death, it must be regarded as nova causa. However, if subsequent conduct extends from the original act, the two will be joined into one transaction. Therefore, the second act would not be a nova causa. In the case of State v. Daniels 1983, the deceased's body had 3 bullet wounds, 2 in the back and 1 behind ear, and the immediate cause of death was the brain damage as a result of the bullet wounds in the ear. Medical evidence showed that the deceased would have died from the 2 wounds in the back, if he did not receive medical treatment within half an hour. Both the accused were charged with murder, but changed on appeal. It was found that A was not the legal cause of death according to proximate cause, and A should only be liable for attempted murder. Furthermore, B's act was a nova causa and was completely independent to what caused the victim to die when he did. Judges gave different reasons on appeal. This is what they have said. According to Judge Nicholas, B's act was the novus causa, A and B had acted in common purpose and by virtue of this, any act B commits in pursuance of the common purpose is regarded as A's act as well. Trengrove Yar argued that this was not a case of common purpose and therefore question of causation should be considered. Amongst other reasons, it was submitted that the accused must be judged by what actually happened, and not by what would have happened in the absence of intervening events. We hope we have equipped you with enough tools to tackle any Novus Actus interveniens question which could come your way. Remember, a Novus Actus interveniens should be new and intervening, independent, abnormal, not foreseeable and have a factual cause. If you found this video helpful, please give us a like, comment and share with your friends. We are forever your law buddy, until the jury do us apart.